Your Honors, I appreciate your time. I apologize for going over. Thank you very much for the opportunity.
SJC-11235, Commonwealth versus Santos.
I misled you into thinking it was one. It's actually two.
All right, let's proceed.
Good morning. May it please the court. My name is Emily Cardy, and I represent Mr. Santos. With me today is Nick Andreopoulos, who is trial counsel. Mr. Santos appears before you in his direct appeal from the Hampden County Superior Court. This court took his appeal sua sponte. And I'd like to begin with the apparent authority issue. Because the mother of the complainant in this case had neither actual authority nor apparent authority to consent to officers entering the home, the motion to suppress should have been granted. Both the couch cushion seized and the buccal swab taken later from Mr. Santos subsequent to the entry of the home.
Now, she lived on the second floor?
The mother lived on the second floor. It's a two-family home, and the grandmother lived on the first floor.
So what are the facts or the circumstances that would have suggested to any police officer, any reasonable police officer, responding to this call, that would have led the officer to think anything other than she had authority?
Well, I think the inquiry is slightly flipped, which is that what would lead the officer to believe that she lived there? And in this,
Let's look at both of them. What would have led the officer to believe she lived there?
well, the factors that he may have seen that led him to believe that she lived there was that she made the 911 call and she met the officers at the porch.
It brought him into an open apartment where the victim, her son, was sitting.
That's right. That's right. The officers, though, should have simply asked, do you live here? And that would be the part of the diligent inquiry that's required under Porter P. and Lopez.
So that's it. As long as the officer had asked, do you live here, what if she said yes? I mean, she does live there.
If she had said yes in that situation, and in this case, I would concede that that probably would have been enough, because in the two-part inquiry of the diligent inquiry, the second part says that if a person says yes, and there are surrounding circumstances that would lead the officer to question that, then the officer.
Is there any ambiguity here at all? We've talked about the facts that would have led a reasonable police officer to believe that she had authority to bring the officer into the apartment where her son, the victim, was.
Right.
Any facts or observations that would have led a reasonable police officer to let anybody to create an ambiguity here?
Well, they didn't have any facts to believe that she did live there. They were relying on their impressions of the situation.
Not their impressions. A police officer gets a call. He says, I'm called to this address in response to a call from a mother whose 12-year-old son was raped by a male member of the household. He arrives. There's a woman at the door, apparently probably a little bit distraught. I'm the one who made the call. Come into this open apartment to see my son. All right? Why isn't that enough?
Because they simply didn't know and they didn't inquire, and they had a response.
Were there two open doors?
Right. So my understanding from the record of the way that the apartment is set up, what the building is set up, is that there's a sort of a threshold door,
Outdoor porch
an outdoor that would lead then into a small area where there would be two additional doors, one door that would go into the first level and the other door that would go into the second level. And so there is some indication that this was a two-family home.
And that both doors were open?
That's right. The first door was open. My recollection from the record, I don't recall whether the second door was open. But there is testimony in the motion to suppress that the officers paused at that threshold door and asked a series of questions. What they asked is not in the record. I don't know what they asked. But at that point, as a part of their diligent inquiry to make sure that she had authority to allow them to enter, they should have asked, do you live here?
Well, okay, what if she said, I don't live here? Does that end the inquiry? Can't authority be delegated, either expressly or impliedly? And wasn't it impliedly delegated here?
Impliedly delegated because she was the one who was, I'm not sure.
The grandmother,
the daughter.
yeah, the grandmother says to her daughter, or essentially implicitly says to her daughter, listen, I'm going to give you control of this. A horrible thing happened to your son, and I'm going to let you do whatever you need to do with the police.
Well, that would imply then that the grandmother would have consented to the officers coming into the home, and the motion to in the record.
No,
reflects-
she would have consented to delegate. She would have delegated authority to her daughter
There's
to
nothing.
manage the situation.
There's nothing in the record to suggest that she delegated
Well,
authority.
the facts. How about the facts?
The facts are
the
that
background facts.
the officers came in.
Yeah, the grandmother's there.
The grandmother.
She's allowing them to mill about freely.
Once they enter the home, the taint exists, that the illegal entry has already occurred. And the grandmother, when the officers asked about the couch cushion, the grandmother in the motion to suppress testified that she just thought they could take the couch cushion if they needed it.
Judge found she readily consented. I think that was her phrase.
The judge, yes. The grandmother's testimony, though, was that she just thought that they had to take it.
Does the record tell us, did the grandmother have a conversation with her daughter before the police arrived?
There's nothing detailing any conversation between the grandmother and
Telling, but does it suggest they talked?
it suggests that the grandmother knew that the police were being called, and
So-
that the grandmother had a conversation with Mr. Santos. But in terms of a conversation between the grandmother and the daughter with regard to who is managing the situation and whether or not the officers will be permitted to enter the home, there's nothing in the record to suggest that.
But at least we can assume, because you say the grandmother knew the police were coming, she discovered that information from the daughter who made the call to the police.
I'm not sure that I can say that the grandmother knew that the police were coming from the daughter. My recollection of the record is escaping me on that particular point.
Could I
Well,
ask
who
you-
else could she have discovered that from?
Well, I'm trying to remember whether the grandmother actually discovered that the police were coming because they were at the door, or because
Is it in the summary judgment record that she told her boyfriend to leave?
she did. That's yes.
So
yes,
she,
thank you.
And
so she
in
did
fact,
have
because
that,
the police are coming, get out of here?
Because get out of here. Yes, thank you.
But there's also some
not the summary
unclarity
judgment
about
record, the motion to suppress.
the police coming in the back door as well as the front door, with the back door with one of her sons who didn't live there.
That's right. There are two officers. Well, there appears to be 5 officers responding to the scene. The 2 officers that stop the client, the 2 officers that respond to the front door, and then another officer coming into the.
And that's the one that the grandmother first sees, the one coming in through the back door.
That's right, and it's with the son who does not live there as well. Yeah, there are 2 open doors.
By the time she gets back, the other police are already inside.
That's right. So she apparently she's at the threshold between the dining room and the living room. She hears some commotion at the back door. She goes to the back door where her son, who does not live there, is with an officer who is entering the home. At that point, she turns around and goes to the front door. And at that point, the officers are already in the home. So she was not near the front door, or the back door for that matter, when the officers were coming into her home.
Now, if I can just go back to make sure I understand, the 2-part Porter P inquiry with regard to the second part, that is where there is ambiguity that emerges, you have to clarify. You're not claiming that there was any ambiguity that emerged during the course of this visit?
No, the claim is that the officers failed to make the required
first
and
part.
essential diligent inquiry.
Okay.
The-
But diligent inquiry is defined as two steps. One, you must rely upon facts, and then the second part is where it turns out that those facts may be ambiguous, you have to clarify the ambiguity. It sounds like you're relying only on the first part, that there were not enough facts here.
Yes, that's right. And the diligence of the inquiry and the reasonableness is measured by what reasonably could be accomplished at the time and the place of the consent. And here, simply asking whether a person lives in a place before officers make an entry into that place is entirely reasonable.
But does emergency come into this at all? I mean, I'm just thinking, here come the police officers, the mother has called, said, my son has been raped, come. I assume there's a lot of emotion and excitement, and they get there, she says, come right in here, he's here. Does that matter? That it isn't, that it's a pretty tense, emergent situation?
Well, I think there are two factors to consider there. First, there's no claim here that there was an exigency that would have permitted the officers to enter the home without a warrant. And so without that exigency, you need consent. And the second part of this is that it's the officers'
Inquiry, the reasonableness of the inquiry.
whether or not there was an emergency.
Well, the facts and circumstances in which the officers find themselves, it doesn't admit of, wait a minute, before I take a step over that threshold, I think I better ask you, do you live here?
I don't think that's an unreasonable burden to place on an officer. Of course, it's understandable that the mother is agitated and excited and feels a sense of urgency. And of course, the officers are responding to the call in sort of their community caretaking function to make sure they're safe and it's a serious allegation. The reason for the dispatch was a serious allegation. However, once they cross that threshold, their function goes from caretaking to investigatory, and there is testimony that they were beginning their investigation to determine what happened.
Did the police make inquiry of the grandmother? Did they ask the grandmother if she lived there?
No.
But you don't dispute that the grandmother had actual authority to let them take the sofa cushion?
The grandmother had actual authority over the premises. The grandmother did ask about the couch cushion.
How do we know that the grandmother had actual authority to live there?
She testified that she lived there, and there is an affidavit in the motion to suppress from my client stating that he lived there with her.
But they never asked her, the grandmother, if she lived there.
That's not in the record, no, that she lived there. They assumed when they were...
They don't need to know that, right? I mean, the fact is she did have actual authority.
Right, the fact is she was the person there with the actual authority.
So that being so, why couldn't, even if the entry was problematic, why couldn't she, as it were, cure the taint just by virtue of the fact that she has actual authority to give them access to the cushion cover? Even if the entry is no good, just even assume that the entry is no good. I don't understand why that's the end of the inquiry here. I don't understand why the person with actual authority to whom the police spoke and said, can we take this cushion cover because it looks stained, and she said yes, and there's no finding or nothing that I could see in the record that suggests she didn't have the wherewithal to make that decision. Why isn't this the unusual circumstance that the person with actual authority actually exercised it?
I think because there was nothing to break the taint of the illegal entry into the home. There's no attenuation here, and so the seizure of the couch cushion is the fruit of the illegal entry. Had they simply asked, "Do you live here?" and presumably the mother would have said, "I live in the second floor," and maybe the grandmother would have consented. We don't know that.
What if the police had come in, the same circumstances we have here, and the mother had brought them in, this is my son and this is my grandmother, and the grandmother said, "Oh, I'm so happy you came. This is so terrible. would that be essentially assent? I mean, you would say, well, the entry through the door is illegal, but is that greeting assent by someone who has actual authority?
That is a different case. And
But the testimony here is that they cooperated. Everyone cooperated. The grandmother cooperated. Everyone cooperated.
the testimony by the grandmother is that by the time the police entered the apartment, she thought that they had a right to the cushion just by the very fact of them being there. And that's the problem with the person who has the authority not being permitted to make the decision as to whether or not they are permitted in there.
Did make a decision about whether or not they could take the cushion cover.
Only after.
And she works for the court system. She's not, she's not somebody who has absolutely no familiarity with police or the court system.
I don't. She works in the clerk's office. I don't know to what degree you would have knowledge of search and seizure law and Article 14 and Fourth Amendment law if you're working generally in the court system. The essential piece here is that no one with actual authority permitted the officers to enter into the home, and the grandmother's silence on the entry of the home and then her assent to the taking of the couch cushion only because she thought that the officers had a right to be there mandates that the motion to suppress should have been allowed.
Thank you, Counsel.
Thank you.
May it please the Court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. In Porter P., this Court determined who can give actual authority to consent to an entry into a home, and that's a household member. Here, the mother of the victim was a person who gave consent to the police to enter the first floor apartment. She was not a household member. She was related to the people who lived in the home, but she was not a household member. She lived in the apartment upstairs. But nonetheless, the circumstances facing the police officers at the time they crossed the threshold were that she had apparent authority to give consent. She placed the 911 call, giving her address, not which unit, but that street address, saying that her 12-year-old son had been raped by a male member of the household. When the police came, she was already outside on the front porch. She greeted them. She told them that she was the person who had placed the 911 call. She brought them through what I believe was the closed main front door, but the two doors to the apartments inside were open, and she brought them into the opened first floor apartment. Sergeant Kent, who was one of those two police officers on the front porch, said that they were the first two police officers to arrive, he and the police officer who was with him. Another police officer came in with the household member, the grandmother's son, who did not live there, through the back, but the first police officers to arrive were the police officers on the front porch.
Now, at some point, they must have learned that it was the grandmother's apartment. Why would they ask the grandmother for permission?
At some point, when they, I think the testimony of one of the police officers was they learned that the grandmother actually lived there, and that was why he asked her for consent to take the couch cushion. She granted consent. They ultimately decided to take the cover of the couch cushion. But
was this I thought he said he learned it only the day of the hearing, or that.
I think Sergeant Kent learned only the day of the hearing, but I think it was a different sergeant who collected the couch cushion cover.
Can I just ask, when you see the two open doors, why wouldn't, the police officers are having conversation with the woman who's let them in through the mother, who's let them in through the front porch door. They come inside, there are two open apartment doors. It doesn't seem like a lot for a police officer coming into someone's home, and the only reason that a police officer can go into someone's home in these circumstances is because of consent, is to say to the person who's leading them in, do you live here?
I think based on what they already had, they thought she did.
But there are two open doors, two units, clearly so.
But she led them into one unit, which to me is part of, she said, when she made the 911 call, this is my address, household member attacked my son. when she's there, I'm the one who called you, and she brings them into that unit, putting it all together, I think, based on those facts, it's not hunches, it's not assumptions,
But they said that they assumed it.
based on facts. I don't think that they use the word assumed in out of a hunch, out of a supposition. They had facts given to them by the mother of the child, which would allow a reasonable person to conclude that she had the actual authority to grant them entry into the premises. Once they were in there, the grandmother, who, based on a conversation with the daughter, because she told the defendant to leave because the daughter was calling the police and the daughter's father. So she thought it best that he not be on the premises because they were there. The grandmother knew that the police were coming because the defendant was already out of the premises when the police arrived. He was found on the street by 2 of the police officers who responded to the 911 call. So the grandmother knew that they were coming. They come in, the grandmother makes no protest. One of the police officers described her as extremely cooperative. She granted consent for the seizure of the couch cushion cover. And as the motion judge found, assessing credibility, the grandmother testified, the police officers testified. She found that the grandmother freely consented to the collection of the evidence.
Does that make a difference in terms of the person with actual authority actually having consented to the taking of the cover, even notwithstanding whatever happened with the entry?
In terms of whether there was, the judge didn't find that there was an illegal entry, so she didn't do any analysis about taint, whether the consent was nonetheless voluntary despite an initial taint. I'd suggest that if the court was going to find that there was an initial illegal entry, then the question be remanded for the judge who had heard from the grandmother as well as the police officers to make a determination whether her consent was nonetheless voluntary, which is a legitimate determination based on the case law, that a valid consent can nonetheless be given despite an initial taint. But here I don't think the judge didn't reach that determination. She had facts before her upon which she could have made the determination, so it wouldn't require further taking of evidence. It would be just based on the record of the motion hearing that she already had to make that. But I submit you don't have to do that because based on facts that were before the police, not assumptions, not hunches, there was enough for them to conclude that the mother had actual authority. So even though they were incorrect in that, because she didn't have actual authority, she had apparent authority based on the facts, and therefore the entry was lawful.
Could you just clarify for me, regarding the mother's phone call to the police, they asked for her address?
I don't know if they asked for it or if she gave it.
But her response said she lived at that numbered house, and she did live at that numbered house.
But there's no indication whether she did not say which unit she
floor,
lived in.
yes.
Yes.
And does the record reflect, when the police arrived, whether there were 2 mailboxes outside or anything to do with that?
The only thing that would show that it was based on the testimony was that there were 2 open doors.
I'm sorry, so basically there's a front door that leads to both units?
Yes.
And was that open when they came?
No, I believed that the mother was on the porch and she opened the front door to let them in. But the 2 apartment doors were open.
Both doors, both of the interior doors were open?
Yes.
And did they both lead into, or did one lead to stairs, or did the other?
That I can't recollect. I know there's a stairwell inside the apartment that leads to the 2nd floor, which the police knew nothing about in terms of what, but there was testimony that the family used that interior stairway to go up and down. That's not anything that was before the police, so it's nothing for consideration here. But there may be more than one stairwell leading to the 2nd floor, but I don't know whether there's a locked door at the 1st floor to that.
What time did this happen?
The incident happened after 2:30 or 2:38 because the grandmother remembers letting the defendant into the house at about 2:38 a.m. And then the 911, the police were dispatched at 4:11. But when the grandmother allowed her boyfriend, the defendant lived there, into the home. The incident between him and the alleged victim happened after he was admitted into the home. The mother had come home at about 1:30. She was already upstairs, had showered and gone to bed when the grandmother sent the child up to talk to the mother. So it happened at some time after 2:30 and before 4:11. The motion judge mentioned that it was an emergency situation, but she didn't find that there was an emergency that allowed the police to enter despite consent. It was just part of the whole atmosphere of the interaction between the mother and the police officers on the front porch.
And when the police entered, was their purpose to speak to the child?
That's who the mother said, you know, this is my son or this is the person who'd been assaulted. She brought them to him and they talked to him.
So that the purpose for bringing them in was to speak to the child who was victimized?
Yes, but when they were speaking to him and heard what he said happened, they noticed a wet stain on the couch and on the floor. And it's that observation during the conversation with the alleged victim that allowed them to ask the grandmother for permission to collect the couch cushion cover. And that had the defendant's DNA in a sperm sample. And I acknowledge that if the search is not valid, then it's not harmless beyond a reasonable doubt here, because although the child testified as to what the defendant did, the DNA evidence is very, very powerful corroboration of what he said. So without it, I think it is harmful if it was an invalid search. If you have no further questions, I'll rest on the other issues in the brief.
Thank you, counsel. All right, we'll take a brief recess.